Hi, everybody. My name is Katie Kestner. I am the Executive Director of the Take Back the Night Foundation. We are thrilled to have talented attorneys with us from our legal support team at Take Back the Night, talking today about the differences between criminal, civil, and kind of campus hearings so that all of us can really understand what avenues are available. When and how. I'm pleased to be joined with my co host, Amy Tilton. Amy, welcome.
Thank you. So, today we'd like to be talking about our National Sexual Assault Legal Hotline, which is a free resource available to all survivors of any form of sexual violence, whether that be sexual assault, rape, sexual harassment, or stalking. And you can call 567 SHATTER, our free hotline, which is available 24/7, or you can fill out our intake form, which is online at our takebackthenight.org website.
Thanks so much, Amy. And I'm going to let our attorneys say just 2 seconds, but they're kind of going to introduce themselves as we go. But for everybody listening and watching, the greatest news is everyone you're seeing on the screen is part of our hotline team. So we have tons of not just talent on our team, we have extraordinary experience and really victim centered support for all of you. So that is what we are all about here at Take Back the Night. And we want you to feel informed and empowered as part of the journey through your healing. So this is one facet of how to do that. So first, I'd like to welcome Guy DeAndrea. Guy, tell us what firm you're with and where you're located.
Thank you, Katie and Amy, for having us on. We're excited to be here and answer any questions and hopefully provide some guidance or some insight. So, as you said, my name's Guy DeAndrea. I'm with Laffey Boosie Law, and we're based out of Philadelphia, Pennsylvania, but our practice is national. And so we help survivors in all sorts of situations across the country against largely those entities that have allowed sexual and physical abuse and violence to occur on their property or under their eye.
Wow, thanks so much, Guy. And we're going to start with our first question for you. I mean, the systems of justice, while you live and breathe them every day, most of us don't do that. And we're only asking for help. Either we've been in trouble, somebody's accusing us of some wrongdoing, or we're seeking justice. And obviously, we're here to help those seeking justice. So, what are those various systems of justice and how do they work?
Sure. And to echo that point, normally when someone says to me, if I ever need you, or if I need your services, I'm going to call you. And I'm like, in my line of work, I'm like, I hope you never do, right? Because that obviously means just a horrific thing has happened to an individual. So yeah, there's at least in what we're talking about today, there's thinking about the systems is sort of three processes potentially, and there may be more, but what we're talking about today is civil justice, criminal justice, and what the campus sort of process looks like if you're going through a Title IX process, right? And so I like to think of the criminal justice system, and this is somewhat of a simplification of it, but you're going after largely the perpetrator who committed the act of violence, of physical violence, sexual violence, both right against you. And that process can be challenging. It can be difficult. It's very important. Don't get me wrong. It's not right for every survivor, but we do speak with all the survivors we work with as that being an option because you are going to handle or hold rather the perpetrator ideally if the process is played out properly accountable, right? And that's usually punishment in the terms of jail time. I'm not saying there's not victim advocacy programs or things that can help with therapy, but largely you're not. I mean, you can see some of that, but you're not going to see a lot of that on the criminal side, right? When I was a prosecutor for 9 years, I thought that was the best form of justice, right? And I still think it's an amazing form of justice. But the civil side can provide such a different avenue of justice for survivors because that's where you don't just hold the perpetrator accountable, right? It's not jail time we're talking about, but what you're doing is you're holding the perpetrator and the institution if there was one involved. And when I say institution, Katie and Amy, what I mean is universities, daycare centers, massage institutions, churches, religious entities, right? So on and so forth. And you get to know what they knew and when, and what they did or didn't do in the face of oftentimes systematic and systemic abuses that became such a way that it wasn't an if a person was going to be assaulted, it was a when, because of their policies and practices. And so through that process, you get answers and you get civil justice, which it is in the form of money. That's what the civil justice provides largely in terms of a remedy. And that can be utilized for medical treatment, self-care. A lot of our clients, because of the trauma they went through, find themselves, by really no fault of their own, right? Maybe they turn to drug and alcohol dependency to cope with the trauma. So that money can help with the treatment. It can help if there's a lack of housing because of the abuse and trauma. There are so many ways and so many options. And then finally, because I know time's limited and there's so much more I can say, obviously, but campus Title IX type processes, um, they're important. The difficulty in discussing them is it really is campus by campus. There's really no standard in terms of, everyone's heard of beyond a reasonable doubt. Maybe some people have heard of preponderance of the evidence. That doesn't really apply in the campus type situation, because it's going to be largely driven by the individual colleges or universities' own internal policies. Some have great policies, some not so much. And some are there really to protect the university, not the survivor. And so,
Mm,
not talking people out of it, it's just
right.
know what you're getting into, right? And really, so it's not about talking anyone out of any one of these systems. Quite frankly, I have many, many survivors who have been through all three systems, right? It's just the real important thing about all this, Katie and Amy, is just knowing before you jump in what you're going to expect. And I think that's largely what Take Back the Night does in providing resources for survivors, and also legal team being able to advise so that a survivor can make an informed decision.
Thanks so much. That was super helpful, Guy. Amy, do you want to ask any follow-up questions?
Of course. For each of those three, is there any reason that a survivor wouldn't be able to participate in the process? Of course, if there's a campus court, that would only apply for those who are at a school.
Sure.
But for civil versus criminal, are there reasons that a survivor can or cannot participate in the process?
Yeah, so I think in terms to answer your question, Amy, is as it relates to civil, I'll focus on in terms of participating in the process. And this is sad, and I'm not justifying this, but because the remedy is financial compensation, and the theory behind it is we can't give you back what was taken from you, right? In terms of the sexual violence, and the only thing we know as a society, but right or wrong in terms of civil, is money. That's what's going to make you quote unquote whole. And I'm not suggesting it will. I'm just saying that's how society views it, or at least the legal system views it. And so, why is that how I started this answer? It's because if an individual perpetrator, let's say it's a stranger rape, right, in an alley, I'm just using that as a hypothetical, there may not be a remedy for a survivor, not because they won't win in civil court. It's because the perpetrator may have no assets or the ability to pay a civil judgment. And so to put a survivor through a civil trial, knowing at the end of the day, the outcome is going to be, yeah, we agree with you, he did it, but that's all we can do for you. I don't know that I would or not make, but have a survivor go through that, versus the criminal system would truly be, if the survivor wants, probably the best avenue for justice.
Thanks, Guy. Let's talk to Marlo. Marlo, welcome. I don't actually remember your last name, but tell us a little bit about you. And my question is going to be a follow up again to what we've been talking about, is these different systems. So perhaps you could talk about, is it even possible or likely that you could do a criminal and a civil at the same time? Guy was just saying maybe there's only really one option, but sometimes both are options. And who gets to decide? Like sometimes I'll hear the police say, nope, you'll mess up our case if the civil case is being pursued at the same time. So can you talk about, first of all, introduce yourself and talk about that?
Katie, thank you so much. And
Mhm.
my last name is Greer, and my law firm is the Greer Law Group, and so that's easy-ish, I guess. One of the things that you said when we first started was take back the night being victim-centered, and that was so important to me because the reason that I got into this work in the first place is because I was sitting in a room full of lawyers who were talking about victims and almost talking about them as a commodity as opposed to someone who needed a voice, and a voice that was not from the shadows. And so Take Back the Night coming out and bringing out that voice is just important, as well as things being victim centered. And I think that that actually is one of the things that's difficult in the legal process, because while my lawyer analytical brain can say, okay, let's do this in this way, my survivor brain is like, what are you talking about? And so, those things are really hard for survivors to understand. The easiest answer to the question is yes, of course, you can do all of these things at the same time. The real answer is, okay, well, it depends. And what's the situation? Like I was talking about, is it something that happened in an alley and it's a person, maybe that person was homeless and had mental health issues, and there's no one that's going to be able to provide financially? Or was that homeless person, had that person just left a shelter or a program where they weren't properly supervised? And if that's the case, then perhaps we can bring the civil claim.
Mm.
I I kind of made a face when you said, as far as detectives saying, "Oh, don't do the civil process at the same time." I will tell you that most of my victims are actually encouraged not to do the civil process at the same time, and so I approach it from, what does my victim want? What does the survivor want? And if we align those goals, and so the criminal process, if the victim wants the person to be held accountable in that way and go to jail, then absolutely, let's do that one. And let's, start there, because there's some evidence that detectives can gather much easier than we can.
Right. Can
Um,
you explain
we
that
have,
just for a second, Marla? That's a
yeah,
really cool point. Nobody really
yeah,
understands.
absolutely. So detectives have the power of the state behind them. The state has the investigators, and they can go out and they can show their badges, and they can request documents that people have to turn over, versus the civil process. I can get documents once a case has been filed, but we do a bunch of investigation before that happens. And ideally, if we can resolve something before a case has been filed, that's almost the best situation for a victim, because it's not all in open court, right? But I have zero power until I file that lawsuit. The state has all of the power. And so they can do a rape kit, they can keep that evidence, they can talk to the witnesses. Of course, a witness can refuse to talk, and that's a whole other nuance of criminal law, but typically they're going to be gathering much more information much quicker than we can.
Well,
We can then
I was gonna go back to
go
I
ahead.
was gonna ask Michael's Nemo's not been talking yet. I want to make sure we hear from
Yeah,
everybody, and I know you two know each other well because you're both in Colorado. Um,
we
yeah,
do.
so let's have Michael. Can I toss something over to you from Marlo? Marlo, you had mentioned you try and settle before filing. Let's explain what that means and how that might happen, because that was I want to make sure we slow the conversation a little bit for people. You're talking really fabulously, but a lot of the people listening to us really need like a little smaller chunks. So let's make sure we go at a
Absolutely.
pace where we clarify each term as it comes up. So Michael, what does that mean? Oh, who are you? And where are you, and introduce yourself, and then maybe talk about like what it means to settle and do this who's doing the investigation. Is it like a PI sneaking around in garbage? You see stuff on TV. I'm like, are they sneaking around getting DNA out of places? What does that mean?
Well, hi, Katie. First of all, I'm Michael Nemo, and I'm an attorney here in Denver, like Marlo. My firm is called the Denver Trial Lawyers. We specialize in all types of personal injury, but I specifically specialize in representing survivors of sexual abuse in the litigation practice. And what you're referring to is in the pre litigation, which is trying to help a survivor get justice without having to file a lawsuit, which is what pre litigation process is. And many times that is the best avenue, in my opinion, for a survivor, because once you file a lawsuit, that is when depositions can be taken and cross examinations of the survivor can happen. And it can be very, very traumatizing and stressful, because they have to share their story over and over, potentially again. And so I always focus on not filing a lawsuit right off the bat and trying to gather information. And one of the ways we do that is, do we use investigators? Yes. Do I have them creep around
Okay.
trash cans?
All
No, I
right.
would never hire someone to do that. But I do get help because there are people out there that are able to track down information related to the perpetrator and or the entity that's involved that I may not be able to find. I mean, their specialty is finding information. My specialty is representing the survivor in the legal system. And so we do use that. We use experts who are, for example, psychiatrists that specialize in sexual abuse trauma that can help with not only the client or the patient's trauma and emotional distress, but can also help with the attorney understanding so that the attorney can then present the case better, the trauma that's occurred from a medical standpoint. Like, do they have PTSD? Do they have severe depression or anxiety? Because those diagnoses makes the survivor's claim more objective and real, which then puts dollars and cents to trying to settle a case. And that's the goal: is can we get them to pay and settle and prevent our survivor from having to go through stressful, traumatizing litigation process.
And in your opinion, Michael, what are some of those tipping points? Is it when you start to gather the evidence enough to come up with something that's quantifiable that you can present to the other side and say, I think we're going to win on this? Or, what are some of the things you found that really help survivors close the deal before you go to file?
Yeah. So first and foremost, we have to be comfortable that we have the evidence that we think we need to prove the claim. So to back up the survivor's story, the last thing we want to do is push the claim too quickly and have the other side just deny everything and call your survivor a liar. That does sometimes happen. But we try to prevent that by building up as much evidence as we can. So that's step one. What I find helps in actually getting a case settled is because if you don't have the initial step of proving the claim, you're not going to even get to first base. But once you get that, getting some quantifiable evidence as to how this has impacted the survivor, like the trauma and the emotional distress, meaning, do they need therapy, and if so, for how long? That helps quantify how much money it's going to cost the survivor, dollars and cents, but also how traumatizing this really is because it's got a medical diagnosis with it. And that makes the claim, in my opinion, a little bit more objective than subjective, which pushes the envelope in getting the case to have some money put on it so that the negotiation can begin.
Yeah. Amy, I was going to ask one more quick question, then I'll turn it to Amy for a question. When we talk about some of these trauma, you said PTSD, post traumatic stress disorder, for those of our listeners and viewers who didn't know what that is. But generally, I always worry that there'll be survivors who are so injured that they're abusing drugs and alcohol, or they've, done some crimes themselves after the fact. Do you have any cases where you're successful even though there might have been bad behavior by the victim, either toward themselves or toward others?
The answer to that question is yes. I do have clients and survivors who've been through that. And what I do is I try to use it to our advantage, and I try to talk about how the only reason they're going through this is because of what the perpetrator did and what the entity did and trying to cover it up. And this is just another objective factor of how impactful this has been to the survivor and how damaging it's been to the survivor. So I try to use it as a positive for their case rather than a negative.
Thanks so much. Allie, I'd like to turn over to you now. If you could first introduce yourself, and then I'd like to address the representation. And for each of the three systems, if I'm a survivor, who is representing me? Do I have my own lawyer for each of the three systems, or is it different for each of the three?
Thank you very much, Amy. That's a great question. Thank you very much, Amy and Katie, for having me here today. I, like my colleague and friend Guy DeAndre, work at Laffey Busey Law, representing victims and survivors of sexual abuse. And with that being said, I'm going to give the typical lawyer answer of it depends who your representation is in these circumstances. If you are involved in a criminal case, then in that instance, the state or the Commonwealth, like we have in Pennsylvania, will be bringing charges on your behalf against the perpetrator of these crimes. Like Guy said, civil remedies, you can get money. Unfortunately, that's the way our system is set up. In criminal systems, we have the ability to get either jail time or fines of that nature. But because the two systems are different, you would be dealing with a prosecutor to that end. Most of them would be coming from the specific special victims unit and have training in how to make sure that your rights and your story is being told in an appropriate way. When you get to the civil side, you have the opportunity as a survivor to choose your civil attorney and to choose the person that you feel most comfortable to represent you and tell your story to potentially a jury and to the institution to make sure that these civil remedies at your disposal are being exercised to the fullest extent. When you get now to the Title IX system, and again, these are all running on parallel paths. When you get to the Title IX system, depending on the university or college that's implicated, you might be provided a victim advocate from the university itself. They might put you in touch with a victim advocate resource center that is a third party organization not affiliated with the university, or you have the ability to go and get your own representation. To that end, if you elect to go and get your own lawyer, they are not able to do the law and order presentation at these investigation hearings like you would expect. They cannot act in the capacity of an attorney. Furthermore, if the university or college is providing you a victim advocate, please make sure that you understand who is paying their salary, because like an HR department who takes the complaint of an aggrieved employee, the HR department's there to protect the company. Similarly, if the victim advocate is paid by the university, it's their job technically to represent you, but also to do it in the university's best interests. So something to keep in mind.
That's super important. I really appreciate you mentioning that, Allie. And before we wrap up our discussion on the, the various systems, the criminal, the civil, and the campus, one thing I always, try and teach when I go around and speak at schools to students and awareness groups is I always like to say there are also these critical differences. How long do you have to file in each of the court systems or judicial systems? So in criminal, we're usually talking a couple of years, but I like our attorneys to come back to this one and explain how come, there's these cases now that happened 50 years ago and how are they being addressed? In criminal, same thing. We've stretched the statute of limitations, but typically it's not more than 8 years for rape a lot of times. And then for campus, usually the person who perpetrated the act has to be a member of the current campus community, whether an employee, a staff member, another fellow student, or someone who has some sort of connection to the institution. So statute of limitations is one. Secondly, I would like to talk about what's the burden or standard of proof. Like you hear people say beyond a reasonable doubt, 99.999% sure that this happened, and that's criminal. But in civil, we have this sort of different system altogether. And then in campus, you can look in all the handbooks and you'll see things like more likely than not, or a preponderance, which is the majority of that. It's like 50.0001% sure that this indeed occurred. So I think those two things, the length of time is really important, and then how long you have to file. And the last one is where it happened. Like what happens if you're studying abroad in Spain and a fellow student assaults you, even though it happened in Spain. Or we could also look at the case where it was summer break and school was not in session. Could you file a case even though it was another student at the beach in July? So I'd like to talk about those like three things really fast before we wrap up our discussion on this episode. So would maybe, I don't know, Guy, do you want to take any one of those three?
Sure. Which one would you like me to address?
You pick your favorite.
So I'll start sort of on the back end then, and I'll let others jump in on some of the statute of limitations because that's its own sort of beast. But you asked about what if someone is abroad? What if someone is off campus, maybe on a break or summer? So again, it depends, right? And it really is a very fact-specific analysis, right? So let me give some definitive examples, and these are not all inclusive, right? So let's say the university knows that their students, this group of students is going, we'll use your example, Katie, of Spain. And it knows that Bob Jones, and I'm obviously making that name up, has perpetrated or has tendencies or has done something violent to another student and allows that person to go anyway and knows that that student is going to be around, let's say female students, and that's maybe who he targets, then I think you have a much, much stronger case against the university because they knew or should have known the propensity or the danger of that other student and allowed that person. We all know what happens to study abroad. There's very little supervision, just quite frankly, right? And so if you know that as a university, how dare you allow a predator to go over there with another group of individuals who may not know that about that individual, and essentially just give him the opportunity to perpetrate there. So I think you might have a pretty strong case under those factual circumstances. Over the summer or over a break, it's going to be real challenging. Not to say you don't necessarily have Title IX potentially, but a civil litigation against the university would be very challenging. But again, don't think to yourself, if you're a survivor, I guess the point in this is, I don't have a case because. Let a
Mhm.
lawyer tell you that.
Love that. Thanks so much, Guy. Maybe Allie, would you like to take one of the other two?
Certainly. I'll talk about the civil statute limitations. So, similar to what my other co-presenters on this topic have mentioned, it depends. And a lot of times what depends is the age you were assaulted. So if you were a minor when you were assaulted, in my experience, more jurisdictions are more hospitable to you bringing claims later in life because they understand the fact that someone who was assaulted as a child may not have the resources, the wherewithal, or even the ability to speak up, and in some cases even realize that what had happened was a crime or was wrong. So, for example, in Pennsylvania, if you were assaulted under the age of 18, you have until age 30 to bring a claim. That buys you those extra 12 years. Every jurisdiction is different though. And if you were assaulted as an adult, some jurisdictions are very inhospitable, and even if it's rape, you only have 2 years to bring a claim. So, to Guy's point, these things are statute of limitations are unforgiving and inhospitable to victims. It is let a lawyer tell you what your options are to bring a civil claim. Don't immediately think that these options are foreclosed to you just because it happened when you were young and you didn't disclose it until you were older. Don't think just because that where the assault occurred, you are foreclosed.
Can I jump in real quick? I feel like Guy and Allie made such great points to let a lawyer tell you if you have a case or not. And that is literally what our National Sexual Assault Legal Hotline is for. We have a legal team who can tell you, give you advice on the best options available for your specific case details. So that is a free resource. You do not need to pay a lawyer to do that. We review the case, and our legal team is willing to talk with you, whether you want to do it on the phone or on the computer. Reach out to us.
Thanks, Amy. That was so great. The last quick point was, Michael, can I toss back to you the, like I was trying to say, like, I think people would, I'll never be able to prove it, or they're going to blame me. So in the criminal, it's, beyond a reasonable doubt, but civil is a lot different. How does that work?
Yeah, so I think using the criminal versus civil is a really good way to look at it because, as mentioned earlier by Ali and I think Guy, in the criminal, the state prosecutor or the district attorney's office is the one who gets to make the decision on whether to pursue your criminal claim on your behalf. And because the burden of proof in a criminal case, a burden of proof means what do you need to prove your case in front of a jury, is beyond a reasonable doubt, which means there can be no doubt whatsoever that this person did this. District attorneys are oftentimes very hesitant to bring the claim into court because they're worried they don't have the evidence to prove it beyond a reasonable doubt. And I have many clients who get so frustrated and traumatized when they're told by the district attorney's office, we've decided to drop your claim. And the reason they're doing that is because the prosecutor doesn't think they have the evidence to do it. And that's really hard for a survivor to hear because what they hear is they don't believe me. They don't believe that this happened. And so for a civil attorney like myself, it's a difficult conversation to have. But what I try to tell them is, look, you don't have a lot of control in the criminal space on whether your case goes forward because it's up to the district attorney. but you have all the control in the civil space. You get to decide if you want to prosecute your claim. And then, the attorney will give you recommendations and advice on the likelihood of success of that claim. And there may be a decision that we shouldn't prosecute, but you are part of that process and you get to help make that decision rather than the criminal process. Because in the civil world, to prove your case in front of a jury, you mentioned this, Katie, it's preponderance of the evidence in almost every state, which means just over 50%. And the way I describe it when I do voir dire and trial, or I'm talking to a jury, is imagine the scales of justice, and they're equally balanced. And if I put a feather on one side and it just barely tilts that scale of justice, you win in the civil case, you lose in the criminal case. And that's all we need, which gives the survivor an opportunity to have their voice heard and have people listen to their story and get their day in court that they wouldn't get in the criminal case.
I love it. Thanks so much, Michael. And I know for our listeners, our viewers, we are going to go step by step through the whole civil system so you can hear from our legal team exactly what it might feel like, what your experience is going to be like. So stay tuned for that episode as well. But this has been such a fabulous conversation. Thank you all for spending some time with us at Take Back the Night and for all your hard work on victims' behalf. We greatly appreciate it. And keep going. Unfortunately, I'm not sure we're going to run out of any cases anytime soon. So, Amy, would you share our hotline one more time?
Absolutely. The hotline number is 567 SHATTER. You can call that anytime. It's toll free. And you can also go to our website, which is takebackthenight.org, and you'll find our legal hotline there, where you can fill in our online intake form if talking on the phone just sounds a little bit too daunting right now.
Thanks so much. And again, everyone take care. Stay tuned. You can get involved with Take Back the Night as a volunteer. We obviously have the Dear Katie podcast. You can hear me talk with all kinds of folks who can help you in your healing process and journey. Take care.